Item for pronouncement of judgment. Item number 1, MSC Appeal 221 of 2020.
Appeal allowed. Impugn judgment and award dated so and so stands better side and quest. And instead of remanding the matter back to the tribunal, we have assessed the amount. The amount is 18,21,927 rupees. Has to be paid within 30 days from today.
Yes, highly
Mention.
Please, your lordship. I beg to mention on urgent matter already, it was fixed on 22nd, but not listed, your lordship. So matter will be listed on the next next for your lordship. November for your lordship.
On 6th
Oh,
November.
For what purpose? Hearing?
Hearing.
It was fixed on 22nd, but not listed, your lordship.
Hearing matter.
Hearing matter only will be in the last part of November.
26th November.
Maybe 19 your lordship.
Not possible. A lot of
No.
matters have already been fixed. Your matter on that day may not reach.
26.
26th November.
May I please, your lordship?
Yes.
Same prayer.
28th November.
May
For same case.
please the lordship,
No,
I
not
beg to
same, but
mention,
same prayer. 26.
28, not 26,
Bless.
28.
may please the lordship, I beg to mention item number 28. In this case, learned counsel F. Begum for the appellant is not well, therefore your lordship may fix the matter after Diwali vacation.
28th.
Okay.
You are appearing on behalf of?
Appellant. I have taken the consent of the other side.
With concern from the other side, Ms. Roy, learned counsel for the appellant, price for listening the matter after.
Diwali vacation.
Take it
On
that one.
11th November.
May it please the lordship. Lordship, I beg to mention item number 6, the engaged counsel had some unavoidable circumstances. So matter may be fixed on, if possible, on 8th November, your lordship. 8th November.
Mr. Your good name?
AP Doctor, your lordship.
AP Dr. Learned counsel appearing on behalf of Miss MD Mary.
Yes, sir.
Learned counsel for the petitioner, price for listening the matter on 8th of November. Okay.
Obliged to you.
May I please, my lord? My lord, this MSC appeal, my lord, I am claimant a respondent, my lord. And June, my lord, the order was passed, my lord, to deposit 50%. 4-month gone, my lord, not deposited, my lord, may come for orders, my lord. For orders on 6th November. No, for orders, for 30 of this month,
No, before Diwali vacation, not
31st.
immediately after reopening.
On 4th.
May I please, your lordship? Lordship, I beg to mention item number 17 on behalf of SK Talukdar. Lordship, the matter may be fixed on 29 October.
29,
October. As my senior is unwell.
item number 17.
17.
We'll hear you.
Okay. As prayed for by Miss
T.R. Oma.
Learned counsel for appearing on behalf of Mr.
SK Talukdar.
SK Talukdar, learned counsel for the accused. Presses a list the matter on
29.
On
29.
29.
Okay.
Lakshman.
Hmm.
Right, please, your lordship. I beg to mention for listing of an RSA for hearing in the month of November.
Take it that one.
Any date
28th November.
of the
Yes.
May I please, your lordship, I beg to mention for listing of an RFA. Matter has been pending since long, so Monday, this matter will be listed on Monday. It is pending for orders.
Next Monday,
For orders.
This will be Monday.
possible.
One
Okay.
case.
Obliged.
May it please your lordship. Lordship, I beg to mention item number 19, lordship.
Yes.
The senior here some personal difficulties, lordship. Can the matter be come after 2 weeks, lordship? Item 19, lordship.
Your good name?
D. Roy, lordship.
D,
D Roy.
your name is not there in the cause list.
I'm
You-
new lordship.
You are appearing on behalf of,
Petitioner lordship. Okay.
where is your name?
T.S. Hazarika on behalf of T.S. Hazarika.
Mr. D. Roy, Learned Counsel, appearing on behalf of Mr. T. S. Hazarika, Learned Counsel for the appellant. Recessal list the matter when?
After 2 weeks lordship.
After 2 weeks. Okay.
Obliged.
May please the lordship, I beg to mention two are distinct lordship in orders column lordship.
When?
On Monday lordship,
No,
Monday, no,
Wednesday lordship,
possible.
Wednesday.
Wednesday. So many cases. No? On fourth?
Yes.
May please, your lordship, I beg to mention, CRP IO for listing on Tuesday.
Oh, in which column? Order column, hearing column, or motion column?
What is the case number? Check question.
Listing, for listing,
What is the case number?
case
Will I-
number,
Okay, Lordship,
yeah.
Lordship,
It's urgent
I'll give a
matters.
date.
It's a fresh matter, actually.
On 6th November,
On
Okay.
6th
on
November.
6th November. Okay. For motion, item number 2,
I believe your lordship. Lordship, it is a case of transfer. Seeking transfer to Tezpur to, from Tezpur to Jorhat, lordship. Lordship, the case is filed by her husband in Tezpur, that also matrimonial 112/2024. The lordship, the petitioner is living alone with her minor daughter, lordship. And it is difficult for her to travel from Rore Jorhat, under Jorhat police station to Tezpur lordship, and she the case is lordship, the petitioner is living in.
You please go to the petition.
Yes, lordship.
We will take it up at 2 o'clock. You have to submit before the court. Be prepared before submitting before the court and appearing before the court.
so item 3,
This may be possible for the time being also.
item 4,
Your lordship, this is a transfer petition, your lordship. Transfer FC civil case number 52/22 from the principal judge, family court number 3 to family court at Lakhimpur, your lordship.
Two,
Lakhimpur, your lordship.
is there family court at Lakhimpur?
Not family court, district and special court. Kindly come to paragraph 15, your lordship. That the petitioner states that the matter is pending before the honorable court at evidence stage, hearing on the day of the evidence, that is on 12/7/2024, wherein both the parties were present, and on the same day petitioner has verbally prayed for adjournment on the ground that as both the parties are presently staying at Lakhimpur, hence the petitioner is going to file transfer petition in the honorable Guwahati High Court for transfer the instant case to Lakhimpur. Therefore, considering above, and after hearing both the parties, prayer for the adjournment is allowed, fixing 12/9/2024 on necessary order. Furthermore, the petitioner states that due to some personal difficulties, he couldn't file the transfer petition before the honorable court, Guwahati High Court, before 12/9/24, whatsoever the next date is fixed on 13 level for necessary order. I have put the annexure also, annexure to your lordship at page number 13, your lordship. Where the principal judge family court number 3 has decided that as the pair of the petitioner considering the above and after hearing both the parties, pair of the adjournment is allowed, your lordship. Hence, your lordship, I have filed this transfer petition, transfer petition civil of 96 of 2000.
Both the parties are now residing at Lakhimpur.
Yes, your lordship.
Then why the case was filed at Guwahati? Family court at
Pilot
Guwahati?
kindly come to paragraph 12, your lordship. The petitioner states that Lakhimpur is a small town and the people know each other, and due to all the above mentioned reasons, he has decided to leave Lakhimpur for some time. Thereafter, he came to Guwahati and stayed here on rent as a tenant, and his address was care of Jitendra Chandra Hazarika, house number 29, Lakhmi Pot, Bailen, Suzola Path, Beltola, PS, Hatigaon, Kamrup Metro, Guwahati. Then come to paragraph 13, your lordship. That the petitioner states that he filed a petition being registered at FC civil case number 52 of oblique 2022 under section 13(1) I and IB of the Hindu Marriage Act 1922.
Okay. Heard, Mr. Your good name?
A count, your lordship.
Learned counsel for the petitioner. This petition under section 24 of the Code of Civil Procedure is prepared by the petitioner for transferring FC within bracket civil case number 52 of 2022 pending before the Court of Learned Principal Judge number 3 Kamrup and Guwahati to the Court of Learned District Judge Lakhimpur. The learned counsel for the petitioner submits that the petitioner and the respondents both are residing at Lakhimpur, but due to some for a temporary period, the petitioner was residing at Guwahati, and therefore he has instituted FC civil case number 52 of 2022 before the Principal Judge Family Court at Guwahati. And now he has again shifted to Lakhimpur, and therefore he preferred the present petition for transferring the case from the Principal Judge Family Court to the Court of Learned District Judge Lakhimpur, District Judge at Lakhimpur. Where is the petition and the documents placed on record? Let notice be issued to the respondents, returnable in 4 weeks. Step be taken by registered post with AD and also the legal process within a week from today. Place the matter after 4 weeks.
Your lordship.
Counsel for the petitioner.
Indeed,
And also considering the facts and circumstances on the record. FC case. FC civil case number 52 of 2022 pending before the Court of Learned Principal Judge Family Court number 3 Kamrup and Guwahati at Guwahati is stands state till returnable that list of performance.
Highly obliged.
Item 5.
Please, your lordship. Lordship, this is civil revision petition, lordship. The petitioner,
No, first tell me, is there any provision in the new amended act
Yes.
regarding extension of this period of limitation?
my lord, as per 166(4) of the MVA, which says, my lord, the claims tribunal shall treat any report of accident forwarded to it under section 159 as an application for compensation under this act. So, my lord, police, my lord, when the FIR was registered within 6 months from the date of accident, then it is the duty of the police to forward the accident information report to the court, to the concerned MSCT tribunal. And, my lord, MSCT tribunal can proceed on the basis of that.
That is the settled proposition of law.
Yes, and my lord, and my lord, to that effect, my lord, there is a judgment, my lord, which says when an accident, when the FIR was lost and case was registered within 6 months from the date of registration.
No,
then-
whether you have inquired from the learned tribunal or from the police station, whether they have forwarded the accident information report to the tribunal or not.
Well, the tribunal, police has not filed any such report to the court. Even I have applied for the accident information report, and then police give me the accident information report, and I have filed the case, But I was under an impression that police has forwarded before the tribunal concerned.
When you have received the accident information report? Have you enclosed that report along with this petition?
I have not enclosed, in preferring this, petition, it's a dead case, 45 days delay has been occasioned. And
That's all right. If it is not provided in the act itself, how the court will extend the period of limitation?
No, when suppose I do admit, suppose police has not forwarded the MSCD, MSC to MSC court, and I have filed it, 45 days, belatedly. Then, in that event, I also have filed one section 5 petition to condone the delay. And against that delay, they have not filed any objection. Other parties have not filed any objection.
No, they may file it or may not file it. If it is not provided in the act itself, what would be the consequence?
No, but to that effect, that issue is pending before the Honorable Supreme Court.
Then
That is yet not decided, but that is pending, regarding this time frame. 6 months.
now you tell me when you have received the accident information report.
For a moment. But presently that is not available with me. But I can show.
Come in the next week then. As spread for by Mr. Dr. Leonard Council. Wednesday.
Always,
Item 7.
তো খবর আছে না? What's on?
Please, Your Lordship, I have filed this revision petition for quashing the order passed by the MSCT 1, Government of Metro Guwahati for rejecting the prayer for amendment of the claim petition due to date of the injured person while the case was pending. See the case July, in the month of July 2021, and the person died in the October 2022 while the case was fixed for
That's all
filing.
right, but while you have filed a petition before the learned member, have you enclosed the PM report of the deceased?
No, Lordship, because the PM report and the
Whether the PM report is available with you?
No, Lordship, the applicants, the injured person died is at the home. So we cannot, we are not in a position to get the postmortem report or cause of death because he died in after 1 year. Lordship, so my prayer is only because the case, trial has not started in this case. So give us a chance to produce the evidence so that we can prove our case. Because we have not, the case, the evidence is not filed in this case. because
That's
the-
all right, but unless you produce the document, medical document or the PM report,
See, PM report and cause of
on
death.
what basis
is
the
not
court below can register the injury case as death case?
That's it. I have filed a medical certificate of a doctor who, under whom he was taking treatment. But we have, because the case was in, trial has not started. So give us a chance.
Where is that document?
Medical certificate is at page number 34, Your Honor. We can call, so if the evidence is produced, we can call the doctor
if he was, and if he died due to the injury or not, so that we can call the doctor. Because the doctor can verify whether he died due to the injury sustained in the accident or not. But cause of death and PM report is not available because he is died at home. PM report, we cannot get the PM report. PM report is not possible. So the court only because we have not filed the postmortem report or certificate of cause of death, the court has rejected our prayer. My prayer is only to proceed the case as death case so that we can file our evidence and prove our case. If if later on it is proved that the disease did not die due to the injury sustained in the accident, that it will be the tribunal can pass an order. But my prayer is only to
No,
pass a cons-
even without registering the case as death case,
see.
you can proceed with the
No, it's
trial.
no.
And if the doctor, if you examine the doctor and it has been established that he died on account of this injury, then court can amend it.
No, if the case will proceed as an injury case, or chief, we cannot file the amendment petition.
No,
death
at the
case
after
as an
examination
evidence.
of the doctor, you can file the petition.
But the evidence will, we cannot file the evidence that he died due to the injury sustained in the accident. That is my problem, Your Honor. But Lordship, because if the case will proceed as injury case, we cannot file our evidence. On the basis of the pleading, we can file. So if the case will
No,
proceed.
no, where is the bar? In mentioning in your evidence in affidavit that the person concerned died because of the accident, because of the injuries sustained by him in the accident. Is there any bar?
If the evidence is based on the pleading, but pleading has not been amended. Because the
Maybe
case,
on the basis of subsequent event, on the basis of evidence brought on record, you can file a petition then.
so that only that
If you do not have any document, then what basis the court
no,
will
we have
proceed
filed a medical
to?
certificate of doctor. He was under treatment, Your Lordship. But postmortem report we cannot get because he died at home. No one can issue the postmortem report. So only that person, the trial court, the MST one tribunal has not rejected the prayer because only because of these two documents, the member rejected the prayer because their documents are not available with us. And the case was long pending due to not filing of the WS by insurance company.
WS by?
Insurance company has not filed any written statement. Till date, they have not filed. The trial has not started due to this. So my prayer is only to file evidence.
Madam, I have gone through the order passed by the learned member MSCP Amin Gaon. There is nothing on the record to show that the order is arbitrary and illegal.
Actually, only page 40, the case will proceed as an injury claim.
Yes.
So that part I am.
Yes. Unless you produce the document, relevant document in support of your claim, how can the court will allow the amendment?
But in paragraph 3 of page 40, Lordship, the petitioner has neither submitted the postmortem report nor any certificate of cause of death. Only because of two documents he has rejected the prayer.
Yes.
But if my prayer is my only direction, that's so that I can submit evidence to prove our claim.
No, you can very well submit your evidence in affidavit. Even without direction of the court.
Only that reflection, if Lordship allowed that
No.
reflection. Because if it gets placed in proceed as injury case, we cannot file our evidence.
You can file your evidence in affidavit. You can establish the fact that the person concerned died because of the injuries sustained by him in the accident. Thereafter, you can file the petition. There is no illegality or arbitrariness in the impugned order.
Only that reflection, whether you can file our evidence to
No, you
provide
can
it.
file the affidavit in evidence in affidavit. Where is the bar? You can explain the facts therein.
Because if amendment is not allowed, then the compensation will be only for the injury case we can file our claim our compensation. But death
Maybe,
benefits will not be
maybe.
granted.
But there is no merit in this petition.
If the case will proceed as an injury case, the applicants will not get the death benefits.
You seems that you have not understand what I have said. We are dismissing the petition. Heard miss your good name?
No, so can we only reflection that we can file our
No,
evidence?
no. No such direction can be issued. Learned counsel for the petitioner. In this
So-
application under Article 227 of the Constitution of India, the petitioner has put to challenge the correctness or otherwise of the order dated 10/7/2024 passed by the learned member, Auto Accident Claim Tribunal number 1, Kamrup M. Guwahati in MSC case number 925 of 2021. It is to be noted here that by the impugned order dated 10/7/2024, the learned member has dismissed the petition number 2410 of 2023 passed by the petitioner under Order 6, Rule 17 of the Code of Civil Procedure for amendment of the claim petition in MSC case number 925 of 2021 on account of death of the injured person, stroke claimant during pendency of the case. The learned counsel for the petitioner submits that one Bhagadatta Barua and Srimati Pratibha Barua have instituted a claim petition under Section 166 of the MB Act before the learned member MSCT, Kamrup Amingao, claiming compensation on account of injuries sustained by the claimant Bhagadatta Barua in an accident that took place at Bapanara village under Bayatasarali police station. And sustained serious injuries on his person. No, for sustaining grievous injuries on his person, and that he was under treatment, and during the course of treatment, he suffered demise on when he died
It is on 16/10/2022.
on 16/10/2022. Then thereafter, the petitioner has filed a petition being petition number 2410 of 2023 under Order 6, Rule 17 of the Code of Civil Procedure for amendment of the claim petition. But the learned member MSCT, Kamrup Amingao by impugned order dated
The Kamrup Metro Guwahati. MSCT 1 Kamrup.
Acha,
Metro
not
Guwahati.
Amingao. Okay. Learned member MSCT number 1 Kamrup M. Guwahati by impugned order dated 10/7/2014 has dismissed the petition.
Please dispose of it. The court allowed to impede the legal hearing.
Hmm. No, dismiss the pair for amendment. No, dismiss the pair for registering the case as a death case instead of injury case. But the learned member is allowed to amend the claim petition showing the petitioner as claimant in respect of the injury of the deceased Bhavadatta Barua. The learned counsel for the petitioner submits that as amendment was not allowed, and the case has not been registered as death case instead of injury death case. That case, the petitioner could not file evidence before the learned member MSCT Kamrup Mem Guwahati. And as such, it is contended that a direction may be issued to the learned tribunal to allow amendment in respect of registering the case as death case instead of injury case. The learned counsel for the petitioner further submits that the petitioner has produced one document issued by Senior Medical Officer Anderighat PhD, Dharam, regarding date of the injured Bhavadatta Barua. But the petitioner could not produce any PM report of the disease since the injured Bhavadatta Barua died in his residence and PM was not conducted. Having heard the submission of learned counsel for the petitioner, I have carefully gone through the petition and the documents flashed on the record and also perused the impugned order dated 10/7/2024. It appears that the learned member has refused amendment in respect of registering the case as death case, as the petitioner could not produce any document submitted the postmortem report. No, the petitioner could not. No, petitioner neither been able to submit PM report nor able to furnish certificate of cause of death of late Bhavadatta Barua. I have gone through the certificate issued by senior medical officer under the PhD, which is available at which is enclosed with the petition as annexure number 2 at page number 34. And it appears that the said certificate issued by the senior medical officer under the PhD is not sufficient to establish that injured Bhavadatta Barua died as a result of the injuries sustained by him at the time of accident. Thus, having examined the impugned order in the light of facts and circumstances on the record and also in the light of the submission. So advanced by learned counsel for the petitioner, this court find no illegality or infirmity or any arbitrariness in the impugned order dated so and so. And accordingly, this court inclined to dismiss the petition.
Item number 8. Item number 8.
May I please, Your Lordship?
Yes.
My lord, in this case, I am the petitioner was they are the defendants. The respondent plaintiff filed a suit for declaration of right title interest and recovery of property. The defendant contested the suit by filing written statement. And the plaintiff side has, after framing issues, the plaintiff side has submitted 3 numbers of evidence and affidavit. On preparation of the for cross-examination of the plaintiff's witnesses, it was found that there is some tag number, pattern number, and area mistakes in the written statement. Therefore, a petition for amendment of the written statement was filed. That petition I have annexed in the page number 35 of cross-examination.
35.
34, page number 34. And the paragraph number 6, page 35. And the amendment I sought for, it is at page 36. That in the line number 11 of para 20 of the written statement, the measurement so and so. These are the amendments of the area of land is to be reduced or enhanced. These are the amendment I sought for in the written statement. Against this, my lord, they filed a reply on my petition. So Lordship can return to
Page number
42. Paragraph number 8. That with regard to the contents made in paragraph number 3, 4, 5, and 6, and it is submitted by the plaintiff that the defendants have introduced totally a new and inconsistent case. Proposed amendment only to overreach the purpose of the plaintiff suit. So the instant petition, the defendant is liable to dismiss. That is the only objection they have raised on the petition. The learned trial court rejected my petition for amendment on the ground that the trial has already been started, but the cross-examination not completed, not started. Only 3 numbers of evidence and affidavit filed by the plaintiff. And while we are preparing to cross-examine the plaintiff witnesses, then we found that there are some mistakes in the written statement. Thereafter, we filed this amendment petition. The learned trial court rejected on the ground that the trial has already been started, and we have failed to explain the due diligence. These are the 2 grounds, and these 2 grounds is not good law at this on this contest matter. The Supreme Court on the other day, Your Lordship also passed an order. The Supreme Court held that all amendments should be allowed.
No. All amendments allowed, that's all right, but subject to fulfillment of that requirement of the provision. That you have to establish your due diligence.
The due diligence, that is not necessary by this law. Your Lordship can. Code of Civil Procedure orders. Amendment are to be allowed which are necessary for determining the real question of controversy, provided that it was not injustice to prejudice to the others.
No, that is the head note. You come to the,
Yeah, last paragraph, your lordship come, paragraph number. Paragraph number 70, 70.
yes.
The prayer for amendment is to be allowed. If the amendment is required to effective the proper adjudication and the controversy between the parties, to avoid the multiplicity of proceeding, the amendment does not render injustice to the other side. The amendment of the parties seeking amendment does not seek to withdraw to clear admission of the parties to confer the other side. The amendment does not raise a time-barred claim resulting in divesting the other side the valuable accrued right. These are the conditions, but the due diligence and the trial has already been started.
Mm.
That point has no use by this argument. And there are
No,
number of-
that is a statutory provision.
No, that is the statutory provision, but
Hmm.
that statutory provision is now been dealt with by the Supreme Court in various judgments.
Mm.
Even though it is a statutory provision, the court for the hands of justice and to proper adjudication of the controversy between the parties, the amendment has to be allowed.
Where is the original written statement?
Original written statement is at page 20.
We'll see if this amendment will change the nature and character of the suit or not. If not, then we'll pass the order. Heard Mr. A. Sharma, learned senior counsel assisted by Mr.
G. Bhai.
learned counsel for the petitioner. This petition under Article 227 of the Constitution of India is referred by the petitioner. Referred by the 6 petitioners, namely so and so, for no challenging the correctness or otherwise of the order dated 12 September 2024, passed by the learned civil judge senior division Goalpara in Milje case number 110 of 2024, arising out of title suit number 5 of 2020. Release the matter on Monday for order. We reserve the order.
Item number 9. Please give me the.
নহ'লে আকৌ হেৰি দিব লাগিব। আকৌ request কৰিব লাগিব। Yes.
Yes, ma'am. Lordship, here my petition was for argument, Lordship, without any evidence, Lordship. So I may kindly be allowed to adduce evidence. Affidavit also have not filed. And without any evidence.
Where is the order of the trial court?
I'll
no,
put in
member.
1611, Lordship. 1611. Trial court order is there, Lordship, in the page 29 to 31. Lordship.
So why you failed to produce evidence since 27/11/2018?
Lordship, because of this COVID-19 and sometimes there was no court also even. And the other side also absent, Lordship. So the case, merit of the case cannot be decided without filing evidence or affidavit, Lordship. And the opposite party should be given chance, Lordship. And they have also not adduced evidence.
No, you have given sufficient opportunity since the year 2018.
Yes, Lordship. But the thing is, that
Huh?
in 2022, there was COVID, Lordship.
COVID
It was
COVID
limited-
continued till when? Last part of 2021,
COVID was on 15/3/22, Lordship.
22. Thereafter,
Thereafter, Lordship, the quote was not there, Lordship. It is mentioned there in the.
Where?
details. The
in the year 2023, there was no COVID.
23, there was no COVID, Lordship. But
Huh?
the
In
Patient-
2024, there was no COVID.
Lordship, this the claimant was seriously injured, Lordship, head injury, Lordship. And sometimes there was no court even, Lordship. And that is mentioned.
You show the dates on which the court remained absent. Where you have mentioned in your petition.
Is mentioned in the Lordship, page number 5, Lordship. Page 4 and 5, Lordship. There are 3-1. And the petition was filed by, claim petition filed by wife only, Lordship. I could not come, Lordship, because of injuries. Page number 5, Lordship. Learned member MCD retired on his date 8/3/22, 2/5/22 was lying vacant.
And remaining dates remaining dates,
The opposite party was absent on 23, Lordship, 26/10/23, Lordship. And 5/9/24.
no, how you are concerned with the absence of opposite party?
Lordship, because the opposite.
We
party
are
has to-
concerned with the evidence.
Yes, Lordship, but the opposite party has to cross, Lordship. Opposite party has to cross myself, me, Lordship.
When you have filed
I have not filed evidence, Lordship. I have not filed evidence because the claimant, he injured, Lordship, he could not come, Lordship. And that is the main ground. My petition was filed by wife only, Lordship.
maybe,
But it's simply my humble prayer that one chance may be given.
no,
Lordship.
we will issue notice, let notice go.
That's it. Thank you. But the date is 16/11, that may kindly be stated, Lordship. Or the decision of the case, Lordship.
16/11.
Lordship.
Before 16/11, we will dispose of this petition.
Lordship, then 16/11, I may kindly will have to give my affidavit, Lordship.
Hmm?
Then quote below, Lordship, evidence.
No,
on
no,
affidavit.
no.
That will be ample helpful to me, Lordship, because I'm the
You,
claimant, Lordship.
you file an additional affidavit indicating the dates on which the tribunal, who is the presiding judge remain absent.
It is mentioned there, Lordship, in my petition report. There are page number 5, Lordship.
For 6
No.
years, you have not been able to file your evidence in affidavit.
Lordship, 3 years there was COVID, Lordship, 16/3/22, Lordship, and 8/3/22 there was no court.
Heard Mr. A.R. Agarwala, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, read with Section 115 of the Code of Civil Procedure. The petitioner challenged the order dated 5/9/2024 and the order dated 38/9/2024 passed by the learned member MSCT number 3 Kamrup M. Guwahati in MSC case number 338 of 2018, by which the learned member has dismissed the petition number 5221 of 2024 filed by the petitioner for adjournment of the case to adduce evidence. Whereas the petition and the documents placed on record, let notice be issued to the respondent, returnable in full, registered post with AD and also by usual process within every from today. Mr. Agarwala, learned counsel for the petitioner, submits that the learned tribunal has fixed the matter on
16/11.
16/11/2024 for argument.
Without
And
any
unless the
evidence, there is no
proceeding
evidence.
is, unless the proceeding is stayed before the learned member, the petitioner will suffer irreparable loss. And therefore it is contended to stay the further proceeding of the MSCT case number so and so so and so. Having considered the submission of Mr. Agarwal, learned counsel for the petitioner, and also considering the given facts and circumstances on the record, further proceeding of MSC case number so and so pending before the court of learned member MSCT number 3 Kamrup M. Guwahati stands to state list of for weeks.
But if the defendant is before my lord, my lord, against an order, where my lord, under order 7, rule 11, the defendant has prepared an application before the London High Court, and that was rejected. But should be pleased to come at page number 32, that is the reviewed order. If I may shortly recapitulate the story between the defendant and the petitioner. The operative portion, the learned counsel on behalf of the petitioner orally submitted in the light of the instant petition 252 of 20 that the opposite party plaintiff side had pleaded in the plaint that the opposite party let out a part of the suit premises to the petitioner. However, there is no specific schedule of the tenanted premises, which is distinctive, identifiable, and separable from the other part of the plain flats unit used by the opposite party as mentioned in the schedule of the plain. Being so, the plea of the petitioner side is that there is no cause of action and barred by the law as per Order 7, Rule 11 AD. It is further submitted that the plaintiff and the defendant are husband and wife and does not have any landlord-tenant relationship. Further, the OP filed the subsequent suit to escape from the liability of TS 7223 filed by the petitioner against the opposite party. Now, there is already a suit pending. On the other hand, the opposite party side filed the written objection stating that the issues raised by the petitioner side is a matter of evidence and cannot be decided at this initial stage. Moreover, It is orally submitted that non-mentioning of any specific schedule cannot be a ground for dismissal of the suit under Order 7 Rule 11. It is merely a technical defect which can be corrected by way of amendment. It is further submitted there is no mention as to why the suit is liable to be rejected under Order 7 Rule 11D CPC. I have considered the submissions of both the parties and I am inclined towards the submission made by the opposite party. The plea, the grounds raised by the petitioner side for dismissal of suit under Order 7 Rule 11 CPC does not hold good. Moreover, subsequent filing of this suit by the opposite party is merely a provision of law for lawfully evicting a tenant as per law and cannot be considered as a way adopted by the opposite party to escape his liability of the previous suit filed by the petitioner against himself. Being so, I am not inclined to grant the prayer of the petitioner, as such the prayer is rejected and the Miss Day case this stands disposed of accordingly. Now, if I may draw my lord's attention, the same court in a different suit which was filed by the defendant, Lord has observed that they are husband and wife. Your lordship will come to page number 35 of the next very page. If I'm reading. Order is dated 22/2024. Both parties are represented. Learned counsel for both the parties appear before this court. And as orally submitted, they have already made their submission in respect of instant Miss J case, Order 39, Rule 1-2, read with Section 151 CBC. Accordingly, the matter is taken up for passing order. The brief of the instant injunction is that the petitioner, Momi Bhuyar Sengupta, who is the dependent and below the petitioner before the lordship, filed a title suit 72 seeking mandatory injunction restraining the defendant OP Anand Kumar Garg from evicting the petitioner and her daughters from the suit premises flat and also restrain him from causing any disturbance and nuisance upon the plaintiff and her daughters until they are residing in the suit premises. It is also free for restraining the defendant from selling the suit premises until a separate arrangement of the accommodation of the petitioners and her daughters are made by the opposite party. The learned counsel for the petitioner be orally submitted in the light of the instant injunction petition that the petitioner solemnized her second marriage on 1/12/2019 and the opposite party after her first husband expired, and presently the petitioner is residing at flat number 54 block this Amarantli Beltalva survey along with the opposite party. However, their peaceful marriage short-lived as the opposite party started torturing the petitioner both mentally and physically and started having an illicit relationship with an unknown lady. As such, the OP started neglecting the petitioner and the daughters and stopped making any payments for the maintenance.
Mr. Betella,
Lordship,
that is sisters land notice to.
Lordship, and Milord, if I may pray, with the proceeding be still for the time. Milord, if your lordship is exercising this jurisdiction on this, Milord, I'll say, Milord, even there is no averment to the effect that the plain reading was done by the court, Milord. There is no averment, Milord, by the London trial court. Only on the basis of oral submissions, Milord, the court arrived, no, this has to continue, Milord. And there is an observation in the second case, Milord, that they are parties and the court already refrained this person to sell the suit. Now, Milord, the situation has arisen with this party. Under Order 39-2, we had filed an application that contumaciously he has injuncted this. He has already gone beyond the injunction order, which was not to restrain. Now the party has to leave the premises also, and he's projecting in all other DV cases that they are landlord and tenants. But this is having a cumulative effect in all the proceedings. Therefore, I pray, Lord.
Heard Mr. Betella, learned counsel for the petitioner. This petition under Article 227 of the Constitution of India, the petitioner is put to challenge the correctness or otherwise of the order dated 19/8/2024, Hospital Learned Civil Judge Junior Division number 1, Kamrup M. Guwahati in Minje case number 29/2024 in PS number 209/2023 under section 115 of the Code of Civil Procedure. That is the petition and the documents plus on record, and also there is the impugn order dated so. It is so noted here that by impugn order dated so the learned Civil Judge Junior Division number 1, Kamrup M. Guwahati has dismissed the petition. While under Order 7 Rule 11 of the Code of Civil Procedure. Let notice be issued to the respondents returnable in 4 weeks. There is only one respondent.
Yes, Milord.
sole
the
respondent
husband-
by registered post with AD and also by usual process. Within a week from today. List the matter after 4 weeks till returnable that further proceeding of TS number 207 of
209.
2023 stands state.
And your placement, grateful.
So item number 34.
My lordship.
Pune order is till 68. What happened, my lord? The suit was filed for specific performance. Initially, injunction application was filed. The ex parte injunction order was passed for maintaining status quo by both the parties. Finally, the Lanet Court disposed the matter by modifying the injunction order, saying that not to alienate. Now,
Not to?
thereafter, another injunction application was filed. I am for the defendant therein. Another injunction application was filed after that.
No, learned trial court, what he did?
First injunction application was filed, initial
Injunction
status quo
granted.
order was passed ex parte. Then, after hearing, the injunction order was modified by passing an order not to alienate
Not
of
to?
the suit property.
Hmm.
It's a case of specific performance. I am the owner of the property and the plaintiff is the intending buyer. Now, thereafter, another injunction application was filed by the plaintiff, wherein he said that I made a construction, owner has made a construction, so not to construct and to appointment of a commissioner in the miss case. Now, without passing any order in the miss case, we have filed our objection also. Without passing any order upon that injunction application and that miscellaneous case, the Learned Trial Court in a main suit passed the impugn order, wherein he again passed in status quo order in respect of the status construction and also appointed a commission in the title suit. Lordship will not find it during the entire judicial career that an injunction order is passed in the title suit and also appointment in the commission. Our High Court in a series of judgments saying that the appointment in commissioner cannot be done without evidence. Our High Court rules also, Rule 230 says that we have to elucidate the dispute only after the evidence. At the threshold, commissioner cannot be appointed. This is 2019 judgment made. So stick real estate. Referring to the High Court rules, our High Court says you cannot. And that too, he has passed in a suit. This is the issue. Apparently misconceived in law, apparently without jurisdiction. Lordship has never heard the injunction
You
order passed
first,
in
no, Mr. Datto, you first show me the first order of injunction.
first order. Lordship will find at page 30. Initial order, it starts from page 30. Lordship will kindly have a look at page 31. Considering all to save the subject matter of the suit, both the parties are directed to maintain status quo in respect of the suit land as on today till next day. This is the initial order, passed out experts. Then the order was modified. Lordship will find at page 40. Operative parties, page 44, my lord. Finally disposed of. In view of above, the interim order dated 17/12/2020 is modified by this court, and the opposite parties are restrained from transferring or alienating the suit land in favor of third person till the disposal of the connected titles to such and such, thinking it to be the right approach towards justice and equity. So finally disposed. We have not challenged, it reaches to finality. Then my lord will find that page 46, another injunction application was filed. On the same facts, replications. On the same fact, page 46,
On 25th of April, the injunction application was filed. What you will find on the first paragraph itself, page 47, the relevant portion of the said petition is reproduced. There is the earlier petition. Now, what you will find page 51. Not 51, hello. Yes. This this earlier case, they have said. The new case, they have said, is page 53. It starts from point B, then is page 53 that on such and such, while the petitioner plaintiff visited the suit premises, found that the opposite party's defendant started construction, etc., etc. These are new facts they have said. Now, prayer is, my lord says, not to raise any sort of construction about the suit land or to change the nature and character, etc. And also prayed for a appointment of an advocate commissioner to inspect the suit land. Now, against this injunction application, we have filed our written objections. Thus, you will find that page 59. Now, this injunction application is, these are some photographs they have filed for construction. Admittedly, we have raised some construction. Because I am the owner, till I am sell it out by an order of the court, I am the owner of the property. Now, page 59, my lord. We have filed our written objection.
No, the question is, can you change the nature and character
No,
of the?
nothing. We are not changing any character. The existing, this is old deployment.
You are admitting that you were constructing
No,
there.
we have in the written objection also, we have, because I am passed an order directed not to alienate. Even if there is some development of the property, if I wants to, by an order of the court, I have to sell it, you will get the benefit, my lord. You will get the benefit with the old price. Now, the issue is here, Lordship will find the impugn order, page 68. Now, that injunction application is pending for disposal. Now, 68, this order has been passed in title suit number 71, 2020. And in the first paragraph, the learned court says, I have heard the learned counsel both the side with respect to prayer seeking injunction so as to restrain such and such. A court cannot pass. Order 39, rule 1 and 2 is separate. And Lordship will find at page 70, the court has passed an injunction order and also appoint an advocate commissioner at page 69. And we are abide by the injunction order not to alienate to any third party. We have not challenged that order also. Commissioner cannot be appointed, my lord. Other invoking
No,
jurisdiction.
is there any statutory bar? in,
This is barred by the judgment of the High Court and the High Court rules. I'm just stating the judgment. Kumari, yeah, that's it. Kumari. 2019-8, GLR 312. Yes, I have, but it's kept somewhere, please. I will get the printout, my lord. Wherein, my lord, Rule 230 of our High Court rules quoted by the High Court, by the judgment, saying that so far the commissioner part is concerned.
Rule
230. I am getting it. So, keep to this. 9. Yeah, it is quoted also in the judgment, my lord. Paragraph 10, my lord, kindly see. Paragraph 10. or she has got. Para 10 of the judgment.
Hmm.
In the further opinion of this court, the purpose of appointing a local investigation is not to fish out any evidence for the contesting parties. It would be relevant to quote the provision of Rule 230 and Rule such and such of the Civil Court Rules and Order of Guwahati High Court, 230, my lord. When a subordinate civil court, either on its own motion or on the application of a party, directs a local inquiry, the order for such inquiry shall be drawn up by the presiding judge himself and shall contain the following matters. A, whether the inquiry is directed by the court proprio motu or upon application, or if upon application from such and such property. What the points are which the requires elucidation or the ascertainment. Such. Now C is important. Why such matter could not be proved or ascertained in the ordinary way by producing documents at the proper time and witness at the trial. The instruction given to the commissioner such and such. The lordship kindly comes to paragraph number 11. On perusal of various case laws cited by the Honorable Senior Counsel for the petitioner, it is seen, as per the ratio of the said cases, it is clear that the purpose of local investigation order 26 rule 9 CPT is not to fish out evidence for the parties where the parties can get such evidence, and it is well settled that the writ can be issued to a commissioner for a local investigation to enable the learned trial court to appreciate the evidence already on record. And only if the court finds that the parties themselves cannot produce evidence to that effect, the court would issue commission for local investigation. Now, lordship kindly have a look at paragraph 14. Therefore, in view of discussion about notwithstanding that the petitioner hearing has paid for appointment of commissioner of her petition number from speaking the misdemeanor case number such and such, the learned trial court is found to have permitted the respondent to collect evidence through the commissioner appointed under order such and such. It is also seen that while ordering the appointment of commissioner, the learned trial court had not recorded its satisfaction as provided under Rule 231C of the Civil Court Rules and orders of the Guwahati High Court. Moreover, by the impugned order, scope has been provided to the respondent for making a roving inquiry, which is not the purpose of the provision of Order 26 Rule 9. Earlier also two judgments of our High Court in 2015 and 2018, my lord, the similar thing has been enunciated that without evidence on record, at the threshold you cannot pass an order. That is the issue, my lord.
Let notice go at this.
Lordship, and further proceeding may stay because the local investigation may not be carried out.
Lord Mr. B. Dotto, Lord Acting Counsel, assisted by Mr. S. Data, Lord Counsel for the petitioner. This petition under Article 227 of the Constitution of India, the petitioner has put to challenge the correctness or otherwise of the order dated 38/5/2024, passed by the learned civil judge, Senior Division Dibrugarh, in title suit number 71 of 2020. It is to be noted here that by impugned order dated so and so, the learned civil judge, Senior Division Dibrugarh, has allowed the pair of the plaintiff, the pair of the respondents herein, respondent number 1, 2, and 3 herein, for appointment of an advocate commissioner in respect of the suit land and submit the details about the present status of the land as well as construction carried out by the petitioner. Peruse the petition and the documents plus on record, and also peruse the impugned order dated 38/5/2024. Let notice be issued to the respondent, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. List the matter after 4 weeks. Having considered the submission of learned counsel for the petitioner and also considering the facts and circumstances on the record, the impugned order dated 38/5/2024. So far, it relates to appointment of a commissioner and to inspect the suit land and to submit a report since state returnable data.
Got it. Get good, man.
Item number 11 for admissions.
May I place your six? My lord, it is there for completion of agreement. My appointment may be placed for in SLC committee, my lord. DLC committee, in DLC committee, I am passed. But in the SLC level, I am rejected as per notice, my lord. My lord, I am BA pass, my lord, and BA pass, and also DLED, my lord. DLED certificate, my lord, 100 please. And 99 page is 98 page is my BAS certificate. 99 page is my computer certificate. I am also OBC belongs to OBC caste, my lord. My lord, 102 page 102 is W2 message regarding my commercial appointment, my lord. By the district elementary education office officer to commissioner and secretary. Page 102. My lord, my name is page 103 and 104, my lord. Para 1A. My name is construct in DL school 104. Page 104. Sri Vyas Chandra Das.
One zero four.
104. Para 1A. Sri Vyas Chandra Das, son of late Vimal Chandra Das. Applied for the post of assistant teacher LP on completion ground. He said proposal was earlier placed before the DLC but was not recommended due to non-ability of the repeated publication during that period. But now this DLC committee is the said case and as per honorable court direction in WC now 5604 2017 recommended the state proposal for the post of assistant LP. It is present agreement as the amendment now assess. He repeated educational qualifications. My lord. My lord, in state level committee decision 26 page 116, my lord. I am rejected because after 1 year, date of my application is submitted. My lord, at that time I was not.
Where you have been rejected? Where it is stated? Where it is stated that your candidature is rejected?
As the candidate applied case 160.
Yes.
Case 160, my lord.
Serial number?
Serial number 2. Sri Vyas Chandra Das.
Yes.
As the candidate applied after 1 year, he is rejected due to non-ability of nouns as per office memorandum dated so dated 1/6/2015. My lord. It is a case, my lord. My lord, earlier,
Where is that office memorandum?
minutes of letter, annex 22. From
Page number?
Page number from 110,
110.
from page 110.
Yes.
My lord,
Hmm.
and this decision of SLC, it clearly violates the order, my lord. High Court
No,
order, my
no,
lord.
I'm asking about this office memorandum.
Office memorandum.
Yes.
Office memorandum is, my lord, office memorandum is, my lord, one page, annex 23, page 125. In, notification is, my lord, page 126, para 3, my lord. Para 3, my lord.
Under this para 3.
Page 126.
Hmm.
If the eligible defendant seeking appointment under this CM's make an application for appointment on commission ground in the prescribed term with all included within 1 year from the date of death.
What is this CM, sir?
Don't know, my lord.
Under this?
CM's make an application for appointment on commission ground in the prescribed term with all included within 1 year from the date of death. Returned the employee with consent letter of retired employee.
CM or OM this is? Under this OM maybe?
OM. This is OM.
So have you filed the application in the prescribed form within 1 year?
No, during that time I was minor. Minor. This is which one my law? Really violence. I will not kindly see page 77. Page 77. Page 28. Honorable Board High Court. Order. This decision of LC clearly violates the Honorable Board High Court.
So after how many days you have applied for?
After attaining the age of majority, my lord.
Hmm?
After attaining the age of majority, my lord.
That's all right. After how many days of death of the person concerned you have applied for compassionate appointment?
Applied for is that's submitted an application on 27/5/2008, my lord.
How many days?
My father is died on 23/11/2006. 2006.
And you have applied for the post in the year
27/5/2008.
20?
7/5/2008.
And during the year 2006, you were minor.
My lord. Kindly see, my lord, High Court order, my lord, page 78, my lord.
Page number?
78.
Yes,
May I read?
only relevant portion.
The father of the petitioner, Vimal Chandra Das, who was working as an assistant teacher in 7 Nang Dhaskal, Bodhana LP school, died in 151, and on his death, the petitioner submitted an application for compulsory appointment. 27. A clear stand has been taken that at the time of the death of his father, the petitioner was a minor and he had filed the application for compulsory appointment immediately upon attaining majority. There is a communication dated 27/11/2015 from the district elementary education officer, commissioner and secretary to the government of Assam in the elementary education department regarding the compliance of order dated 23/6/2015 on of this court by WBC Nong 370/2015. We have taken note that in order dated 26/2015 WBC Nong 3703/2015 there is a direction to place the claim of the petitioner for compulsory appointment before the next available DLC of Dhubri district. Accordingly, the application was placed before DLC Dhubri district. It is meeting held on 18/9 to the back. The DLC had rejected the application of the petitioner for non-submission on application within a period of 1 year. We are considered to observe that the DLC headed by the deputy commissioner did not act as per law in rejecting the application on the ground of being submitted after a period of 1 year from the date of death. It is not an inflexible law that it has to be submitted within a period of 1 year. And there are also other related laws which the deputy commissioner ought to have been aware of. Firstly, it is clear stand of the petitioner that the application for compulsory appointment was submitted upon attaining majority as the event of when the date of had occurred. The petitioner was a minor, and in this export, the law had also been laid down by the Supreme Court on the acceptance of such application. Secondly, when there is a clear mandamus from this court for the application to be placed before the DLC, it is understood that the DLC would consider it on merit and not reject it on a technical ground. Inasmuch as the court, with passing the order, had not taken such technical issues, but that as we may, the aforesaid circumstance, the communication dated 27/15 had been made by the district elementary education officer Dhubri. The district elementary education officer Dhubri is now concerned as to what has to be done in this case, and therefore makes the communication to the commissioner and secretary in the education department seeking the advice as to what has to be done. And the district elementary education is also equally concerned as to how the period of 1 year can be controlled. All we can say is that this is the story state of affairs of the authorities in the deputy commissioner as well as district elementary education officer in being ignorant about the actual position of law. A further question has been raised by the district elementary education officer whether there can be a election for requisite qualification to the post officer for compulsory ground. The district elementary officer be informed in clear was that it cannot be done, but at the time of the district elementary officer ought to have been aware of the fact that an application for compulsory appointment is made against a suitable court for which the inquiry may be qualified for, and it is not necessary that if the deceased had worked as a teacher, the compulsory appointment also have to be made against the post officer. The same answers to be query of the district elementary. Accordingly, the district elementary officer is directed to immediately place the application of the petitioner for compulsory appointment before the next available DLC Dhubri district, and DLC would consider the claim for petitioner against any suitable vacant post for which the petitioner may be duly qualified. In doing so, the DLC shall take note of the relevant qualification that the petitioner may have. The read petition is disturbed. Answer the page 102. W2 by the district elementary. Page 102. My lord, and there are also some case, my lord kindly state where it says, para 21.
Yes, Mr. Bhattacharya, in this order, there is specific direction.
Yes, my lord. My lord, whatever the Standing Council of Education Department is not present, I'm appearing for the state.
I'm appearing for respondents 2 and 4,
Hmm.
the district and the state district committees. And from the state, I can show it very clearly that this court has already disposed of this case once.
Hmm.
That is on 23/1/23, the judgment is annexed at page 107.
Hmm.
So that everything has been made clear, my lord, that it has become infructuous, the case. That means it was not considered, their case at that time was that it was not considered by the state level. Then under the court's order, it was considered. And then later on, they again approached this this court. Then this court then again said that since now the state level committee had considered the case and rejected it, and now it is infructuous. So the order is there at page 107. Everything has been explained, my lord. So, my lord, you can dispose of this case, my lord. Because there is no other way, my lord, because everything, now one thing my lord is considering it very compassionately, and I'm not against them. What I suggest that at that time, if the mother, the widowed mother they have admitted was there, she could have applied at that time. Then this would not have happened. So it was what has happened, my lord. So now what can be done? So at that time, a wrong decision was made, my lord. If the widow wife had applied at that time, she could have got it. But now it is too late. It is page 107. The order is there, and I can read it out also, my lord.
No,
can-
this WPC number 830122, was it against the decision of the state level committee?
What happened just now? He had already argued. What happened? The district level they have the case that it was not forwarded to the state level committee.
Hmm.
And then after that, after this High Court judgment, it was then reconsidered it was placed before the state level committee, and the state level committee dismissed it. That I can read out at page 109, man. It is very clearly explained. Can I read out my?
No.
Yes, that question, my lord, is asking, that answer is there here, page 109.
My mother was Eli person. It is in the petition also, it is mentioned. My mother was Eli
No,
person.
but he has admitted that they have applied for after almost 3 years, my lord. So what can be done? The rules are against it. May I read out page 109, my lord?
No, maybe, but in the order of this court dated 27/10/2021, it is stated that it is not inflexible as per decision of the Supreme Court.
Yes.
Hmm.
No, after that, what happened? It was placed before the state level committee.
Hmm.
The state level committee dismissed it. Now, what can be done, my lord? No, this is a read court, my lord. Read court cannot, it can only question the procedure. Now the question was the procedure after the court's order,
Hmm.
it has been complied with. So that has been stated in the High Court order. And so now the decision cannot be changed by the court. Now that is, how is it technically not possible? And my lord, if doesn't want the Education Department Standing Council is not present today. So she is present, my lord.
Hmm.
She is representing the state, the Education Department.
Hmm. Yes, Mr. Bhattacharya, you saw that order of this court where everything has been considered? Page number?
Page number 109, my lord.
Yes.
During the deliberation of matter, Mr. S.R. Borua, learned government advocate Assam, has placed a copy of the minutes of the state level committee for compassionate appointment dated 26/8/2020, which goes to show that the case of the petitioner was placed before the said state level committee and the SLC concerned in its meeting held on 26/8/22 rejected the case of the petitioner for his compassionate appointment as an assistant teacher of the lower primary school, as he had filed his application for compassionate appointment after 1 year from the date of the death of his father, and due to non-ability of the norms as provided in office memorandum number dated 1/6/2015. Since the state level committee for compensation in its meeting held on 20 rejected the case of the petitioner for his compassionate appointment for consideration, this petition being infructuous stands dismissed. Petitioner is so advised may approve the appropriate forum for redressal in pertaining to decision of state level committee for compassionate appointment stated 2020 noted above. Mr. Borua, learned advocate, government advocate, Assam shall serve a copy of the minutes of the SLC dated 26/8/22 to Mr. A. Dutt, learned counsel. Necessary acknowledgement in this regard for his necessary use and inform the petitioner about the said decision of SLC. So this is also right now. So it is dated, my lord, it's still waiting for the pending, the education department. So now what can be done, my lord? There is no other way, my lord. It has to be this. I mean, how can anybody do anything?
No, Mr. Bhattacharya, in this order, liberty is given to him to approach the appropriate forum,
Yes.
challenging the state level decision of the state level committee.
So,
This
my
is
lord,
second
the,
AO.
these minutes of the are annexed at page 20, at page 110. So now, so that did not find it, the petitioner qualified. So what can be done, my lord?
No, in this petition, he has challenged the state level decision of the state level committee.
Yes,
That liberty is given in this order.
yes. Yes, but then the state level committee did consider his case. So after that, it was
No,
found
state
that,
level committee reasoning is that it is not in compliance with the office memorandum. It is stated in the resolution.
yes. My lord, that is the education department will be having it, my lord.
And in the order dated 27/10/21, it has been stated that this is not inflexible rule. You see the paragraph number 4 of the order dated 27/10/2021.
My lord, here, my lord, this ground is there and another ground is there that he has to be the most poorest of the applicants. But then somebody more unfortunate than him was found also, I think that is why also, my lord.
Where it is mentioned.
That has to be, my lord, my
No,
lord.
you saw it from the decision of the state level committee.
Yes.
From where you are submitting this?
My lord, that office memorandum is there at page 125. My lord. So there it at page 126. Every at paragraph 3.
Hmm.
Every, towards the bottom at page 126, marked as paragraph 3, my lord.
Hmm.
Every eligible defense seeking under this OM shall make an application on compensation grounds in the prescribed form with all enclosure within 1 year from the date of acceptance of the retired employee with the consent or letter of the retired employee.
Hmm.
In case of missing, governments have a request to grant benefit of compensation amount can be considered
Hmm.
only after a lapse of 7 years from the date of lodging a FIR with the police authorities provided that the missing person is not traceable as per police report and the competent authority feels the case is genuine. Now, my lord, this is the uh, it is stated here under what circumstances a applicant can file his application
Hmm.
after 1 year. But
That's all
this-
right, but this rule has
this-
been, Mr. Bhattacharya, this rule has been interpreted in paragraph number 4 of the order dated 27/10/2021.
Yes. Yes, but then in Assam, my lord,
Hmm.
this and that Supreme Court case, I don't know from which state it has gone, my lord.
Hmm.
Because here, under our rules in Assam,
Hmm.
only when a person is missing, a person can apply this after a lapse of 7 years, till 7 years, that is.
Hmm.
But in this case, that has not happened. Here we know that his father had died and his mother was alive, my lord, at that time. She could have applied. Now, my lord, the rules does not allow it now. There is no other way now.
No,
And
the
my
rule
lord
has
is
been-
saying that about the
Mr.
Supreme
No,
Court.
no,
and
Mr.
that-
Bhattacharya,
Yes.
this has been interpreted in paragraph number 4, that it is not inflexible rule.
Yes. Inflexible provided it is allowed under the rules, my lord.
No, no.
In certain states, it is allowed under the rules, outside Assam, I mean. So that is why that I know, but then to show everything, my lord, I will have to require some time, my lord, because
Okay, all right, you produce it on Monday. We'll adjourn the case till Monday.
Yeah.
Yes, madam, what is your submission?
Two judgment, my lord. Two judgment and also another judgment, my lord. Decision, 3 years, cut off, mark. She's Devajit Dua, judgment. Notification,
Furnish a copy of the same to Mr. Bhattacharya also.
cut off, mark, notification challenging.
You furnish a copy of the judgment to Mr. Bhattacharya also and to the court
I
also.
furnished the judgment to Pavitra Shekar.
Yes, madam, what is your submission?
Already.
Order of conviction and appointment and GLC recommended the name of the petitioner, but SLC rejected the name. SLC is represented by the government advocate that instruction is properly placed by them.
Hmm.
Education is just a formal party.
Hmm. Okay, Mr. Bhattacharya, we'll fix it on Monday. Third, Mr. Adas, learned counsel for the petitioner, and Mr. Bhattacharya, learned counsel for the respondent number. You are for respondent number? 4. And madam, you are for?
1.
Respondent number 1,
3 and 5.
1, 3, and 5. Heard in part, list the matter on Monday for further deliberation. We'll resume after 5 minutes.
Well.
Okay.
It's a statutory appeal filed under section 96 of CPC against the judgment and decree dated 26/3/2023.
Have you filed an amended cost title here?
No, Lordship, actually, we went to filing section. They have said that we don't have to file any amended RFA. That's lower court,
No, the forms are different.
but they have said that no need to change the format as it is a transfer case.
No, transfer means a different forms are adopted in the district court and in the high court. Hmm? Bobby? Oh, I applied form they say actually to level. You will not from district court or তো ইয়াতে amended data তো দিব লাগিছিল আপোনাৰ transfer এবাৰ section মাতি আমি bill yes
So Lordship, notice may be issued.
Pardon Ms. R. Saha, learned counsel for the appellant. In this petition, no, in this appeal, under section 96, within bracket 1 of 1, read it. Order 41, rule 1, read it. Section 51 of the CPC is directed against the judgment and decree dated 26/3/2021, Hospital Learned Civil Judge Kukurajar in title sub number 14 of 2015. Here is the memo of appeal and the grounds mentioned therein. Let notice be issued to the, no, and also peruse the impugned judgment and decree dated so and so, so and so. Hospital Learned Civil Judge Senior Division Kukurajar in title sub number 14 of 2015. Let notice be issued to the respondent, returnable in 4 weeks, that be taken by registered post with AD and also by usual process within a week from today. Register shall call for the record from the Learned Civil Judge Senior Division Kukurajar. Place the matter after 4 weeks. Admit me.
Item 13.
Record to already call police and a letter when it appears that the record has already been received. Call police. Letter call person second district court. Paper পঠাই দিছে directly. Record of title have been
ট্রান্সফার পিটিশন কল করা হয়েছিল কল করা হয়েছিল বলে করা হয়েছে ট্রান্সপোর্টেড এই কেসটা দেখে
Item 13.
May it please the Lordship. Lordship, this is statutory appeal, Lordship, against the judgment and decree dated 16/8/24, Lordship, passed by the Learned District Judge Morigaon, dismissing the
of the mediation. And my client is also agreeable to them. In fact, the fact is such, the 3 cases are pending. They are the husband and wife. I am the husband. Krishna is the wife. She filed 3 cases pending in the Guwahati. I have filed a divorce suit in the present petition is filed for transfer of the proceeding from Biswanath Chariali to the Guwahati. These are all matrimonial disputes, my lord, connecting with husband and wife. So therefore, my lord, the matter can be tried to be disposed of or sorted out by the mediation. Court may be pleased to refer to the mediation of Guwahati.
High Court Mediation Center. Heard Mr. D. Dale, learned counsel for the petitioner, and Mr. P. J. Sukia, learned senior counsel assisted by Mr. P. Bordoloy, learned counsel for the respondent. It is submitted at the bar that both the parties are agreeable in sending the matter to the Guwahati High Court Mediation Center. Accordingly, it is provided that refer the matter to Guwahati High Court Mediation Center, and the parties are directed to appear before the mediator on or before.
For the election duty, I am now presently at the Bihali, my lord, I am on election duty after 23rd of November, any day.
Suggested that
December
1st
first
of December, my lord,
6th December.
6th, my lord, yes.
6, December 6.
Item 15,
Interim with us, interim may be continued.
Interim order passed earlier shall continue.
item 15,
Wait, please, your lordship.
Hmm.
Here, lordship, I omitted to file one IA, lordship. I may be allowed to file that IA, so I am praying for an adjournment today, lordship.
Your heard Mr.
Take on.
D. Colita, learned counsel for the appellant. Mr. Colita submits that he will file an IA in this appeal and press for listing the matter after 1 week,
Lordship,
or we'll fix a date
after 1 week, lordship.
after 1 week. Okay.
Lordship.
Fair, good.
item 16,
Lordship, this may be taken after 1 week. I could not find a supporting file today. Perhaps I'll need to file an application.
Okay, Mr. R. Goswami, learned counsel for the appellant, submits that the matter may be listed after 1 week. Fair allowed.
for bail hearing. Item 18,
May I please, your lordship? Lordship, this is a bail petition under section 482 of the NSO. Connection with Agumoni PS case number 0/2024. Last order CD was called for.
Mr. Boisho, you have received the case.
My lord, CD received, my lord, in this case. My lord, before going to the material, my lord, or the facts of the case, only one thing, my lord, I would like to bring to notice of this honorable court, my lord. My lord, here there are the two orders, my lord, reflected here passed by the learned session judge, my lord, Dhuburi, and one by my lord, learned special judge Foxford, my lord, Dhuburi. My lord, here the FIR reflects that is the, though it is registered under, my lord, this matter is registered under 365 34 IPC, my lord. But my lord, when in the contents of the FIR, the age of the victim is stated as 17 years, my lord. And my lord, in this connection, though they have not added any section, my lord, under POCSO, but my lord, there is one bail petition, anticipatory bail petition that is they filed before the session judge, and session judge in this regard, my lord, make this opinion that on the 164, some ingredients are there, and so it transfers the petition to the POCSO judgment. Lordship. But my lord, 164 is there.
Mr. Boisho, the question is whether the case has been registered under the POCSO Act or not.
My lord, that is not registered. Even I take the instruction from the OC.
Then on what basis the special judge will take cognizance of the same?
Lordship, kindly see paragraph.
That is not added even.
One by one. Yes.
That is not added. That is not added, my lord. And even thereafter, only that order is there. Other than my lord, 15 item number. Only that part only I would like to be.
Lordship, kindly see the para number 5 in the petitions. That the petitioner begged to state that he has a love affair with the daughter of the informant for last 3 years. And the same thing was stated in 161 and 164.
in her statement. The informant, knowing the fact, had arranged the marriage with another person to be
Okay,
solemnized.
okay, we will see 164 statement is available.
Yes,
People are available.
Your Lordship.
On that part, my lord. Nothing, so only I.
Lordship, she clearly stated in 161 and 164 that since she has not attained the age of majority, therefore
I am not asking you now. So in the bail petition, district judge has referred the matter to POCSO judge.
My lord, only
Thereafter
that,
what happened?
only that,
Bail petition was referred to session, no, POCSO judge.
my lord, by the learned session, just Dhubri,
Yes.
my lord,
Or what,
my lord, by the learned session, just Dhubri,
Yes.
my lord.
or whether that bail application was disposed of.
That is disposed of, my lord. That is there. On 6/9 order was there, my lord. They didn't appear and that was disposed of, rejected, my lord. I have flag mark, my lord. The first one of the order, it was 6/9, my lord, most probably. Five nine is the session judge order. 6/9 is the special judge POCSO, my lord.
So as per this birth certificate, what is her age?
Age on the date of incident is, my lord, that is
17
17 years, 10 months, 15 days. And that is reflected in there also. Below 18 years.
17 or 17 months, 15.
Oh, sorry, 11 months.
11 months, 15 days.
11 months, my lord, not 10 months.
Yeah, that-
17 years, 11 month.
15 days.
15 days, my lord.
Okay.
Date of incident is 19/1/2024, my lord. And date of birth is 4/2/2026, 2006, my lord.
Yes, now submit.
Lordship, at the time of the incident, she was 17 years, 11 months, 15 days. Lordship, I have annexed a marriage agreement. There is annex 4.
That is after the incident.
Yes. Lordship, that the statement of the Alice victim girl was recorded under section 161 and 164, where she clearly stated that she in a love relationship for last 3 years with the petitioners. And she
Now
also stated,
you come to the definition of section 2D of the POCSO Act.
Appeal is not liable. So revision is liable. After revision, they have withdrawn the revision. Now the defendant number 1 tried to dispossess the defendant number 2 from the suit land. By way of, you will get the possession of the suit land, which is my land. This is the substantial question, that section title suit number 68 is not binding upon me, and that is finding is there. There is no res judicata. Both the court below tell that it is not res judicata. But the finding regarding his position on declaration, they dismiss the suit, my suit. That is number, my lord, substantial question number A, my lord. And B, my lord, whether the learned court below committed perversely by not appreciating the exhibit 2, that is Jamabondi and second arrest pattern number so and so, where the name of the ancestor of the plaintiff is recorded and not considering the plaintiff's claim over the suit land by the right of inheritance. So here, my lord, we have exhibited the Jamabondi only. In Jamabondi, our ancestor name is there, my lord. And there is no dispute that I am the heirs, one of the heirs. But learned trial court rejected the Jamabondi, holding that the mutation entry cannot get title. So I want to rebut this
by the judgment of the Honorable Guwahati High Court, my lord. My lord, I'm reading the heading, my lord. Assam Land and Regulation, Section 4056, Record of Rights. Entries in the record of right, that is Jamabandi based on Chita, are to be found on the basis of actual possession. Such entries raise a presumption regarding possession in favor of the recorded party unless rebutted. So, my lord, there another judgment, 1998, 4 GL, 1937. Assam Land and Regulation, 1886, Section 3, Pata must be considered as a document of the title. Assam Land and Regulation, 1886, Section 4041, record of rights shall be deemed to be correct unless contrary is proved. Mutation entries may not be the basis of the title, but those cannot be ignored and must receive due consideration of the court. My lord, in this judgment, my lord, Honorable Guwahati High Court distinguished the Supreme Court order in para 6, my lord. Regarding the entry, the revenue record, Mr. Sharma Learned Council relied on the following. In 1997, 1 SCC, that was a case from the Allahabad High Court. There, the Supreme Court pointed out that the mutation entries usually do not confer title to the land. Title is derived from the sale deed, properly stamped and registered. That was the case with regard to the acquisition of the ceiling surplus land, and the landholder claimed exemption on the basis of the mutation entries. And that was not accepted by the Supreme Court, holding that the mutation entries cannot create title. That case does not help the appellant. Further, under the Assam Land and Revenue Regulation, there is a provision how mutation entries are to be made, how Jamabandi are to be granted, and how Sita are to be corrected and prepared. These provisions have been there. If these records of rights are prepared and maintained in accordance with the law of the consonance with the provisions of the state regulation, they have certainly evidentiary value to establish the title of the person. Otherwise, whole Assam Land and Revenue Regulation and provisions of the issue of patta and also the Jamabandi shall be OTS and irrelevant. That cannot be purpose of the Assam Land and Revenue Regulation. So, my lord, revenue entry, two kind of revenue entry, my lord. After settlement period, my lord, after measurement of the land, the revenue entry is made, my lord. And thereafter, record of right prepared. But during the non-settlement period, what settlement is over, so we file a mediation petition. Then we have to prove our title by registered sale deed. But if we are inherited, and subsequently in the settlement operation, when the settlement operation is going on, then if my name is recorded as per heirs and successor, then, my lord, that is valid title, my lord. Because I have no sale deed, my lord. There cannot be a sale deed for inheritance, my lord. So that is, my lord, one of the substantial question, because the Jamabandi entry is good title, my lord, but this is my lord. At this stage, my lord, this substantial question, two substantial question is sufficient, my lord, if your lordship.
This on the basis of earlier titles of 68
Yes.
of 1992.
Yes, my lord. That is suit for specific, under specific purpose, under 6 of the specifically legal. Yeah. That is between parties.
Specific.
Section 6, maybe. If any person is dispossessed without the consent of involved property, otherwise than in due course of law, he or any person to whom he has been possessed or any person claimed to him may be by suit recover possession thereof, notwithstanding any other title that may be set up in the such suit. My lord, if a person is dispossessed from a land under his position without following due process, then he can file a suit under section 6 for recovery of possession. In spite of the fact that he may not have title, within 6 months he has to file. In that case, no title will be decided, and therefore there is no appeal. The title suit under section 6, there is no appeal, and subsequently it is stated, no suit under this section shall be brought after the expiration of 6 months from the date of disposition or against the government. Next, no appeal shall lie from any order or decree passed in any suit ensued under this suit, nor shall any review of any such order or decree be allowed. So, it is court will decide in the under section 6 petition, whether the prior to institution of the suit, 6 months prior to this, whether he was in possession or not, and he was dispossessed by without following due process of law. Then, like a 145 proceeding, it is decreed, recovery possession will be decreed. So here in this case, that suit was between the defendant number 1 and 2, not with me, So they raised the question of res judicata, that was rejected by both the court, this is not res judicata. But the injunction against the taking possession of the suit land by way of that decree, that was not given to us. That is point number.
Okay, heard Mr. P.K. Dekal, learned senior counsel, assisted by Madam. Learned appellant. This appeal under section 100 of the Code of Civil Procedure. The appellant have challenged the correctness or otherwise of the judgment and decree dated 3/11/2023 passed by the learned additional district judge Hailakandi in title appeal number 2 of 2018. It is to be noted here that by the impugned judgment and decree dated so the learned first appellate court has dismissed the appeal by upholding the judgment and decree dated 28/3/2018 passed by the passed in title suit number 14 of 2010 by the learned trial court of civil judge Hailakandi, dismissing the suit of the appellant. Peruse the memo of appeal and the grounds mentioned therein. And also peruse the impugned judgment and decree dated so and so. This second appeal is admitted for hearing on the following substantial question of law. Number 1, whether the learned trial court as well as the learned first appellate court have committed perversity by dismissing the present suit. By dismissing the title suit number 14 of 2018 on the basis of earlier title suit number 68 of 1992 under section 6 of the Specific Relief Act, wherein the original plaintiff of the present suit who has not made a party to the earlier suit. Number 2, whether the learned courts below committed perversity by not appreciating the Exhibit 2, that is the Jamabandi of second arrest patta number 62, wherein the name of the ancestors of the appellants, present appellants, is recorded and not considered by the appellants, and not considering the appellant's claim over the suit land by right of inheritance. That third question is required or not required?
It may be formulated, otherwise it will be difficult.
and whether the learned courts fellow committed perversity by misconstruing the exhibit 2, that is the Jamabandi, with the entry of mutation during non-settlement period and arrest dated during resettlement operation, which are different in its character and status.
In this case is Jamil.
Let notice be issued to the respondents. Returnable in 4 weeks that be taken by registered post with AD and also by usual process with an from today. RSSL call for the records from the learned trial court as well as from the first appellate court. Place the matter after 4 weeks.
In this case, Milord, for injunction, Milord.
Let notice go at this.
Yes, Milord.
Notice.
Transfer petition, Lordship. Lordship, there are 4, Lordship. The petitioner receive a notice issued on 08/08/2024 along with a copy of the petition of title suit matrimonial case number 112/2024 from the office of the additional district and session judge Sonitpur, Tezpur, whereby she was informed that, Lordship, the respondent filed a petition under section 9 of Hindu Marriage Act 1955 against the petitioner for seeking decree of restoration of conjugal rights, Lordship. Lordship, on 27/11/2009, Lordship, the petitioner and the respondent solemnized their marriage at Jorhat and as per Hindu rights and rituals, and they are started living together at Jorhat, Lordship. Lordship, the petitioner has a minor daughter, Lordship, and Lordship, the petitioner is living alone with her minor daughter in a rented house at Jorhat, at Rongai Gaon near Air Force Station, Roroya, Jorhat, Lordship. Lordship, the petitioner is working as a ward Sahayika at 5 Air Force Hospital, Lordship, and Lordship, it would be highly inconvenient, Lordship, to travel all the way from Rongai Gaon, Jorhat to Tezpur to contest and appear before the learned additional district and session judge.
What is the distance between Tezpur and
Lordship,
Jorhat?
approximately 350 to 400 kilometers.
Jorhat to Tezpur?
In a single day, Lordship.
Jorhat to Tezpur?
Jorhat to Tezpur. Up and down, Lordship.
Heard, Mr. Your good name?
DJ Boro, Lordship.
Learned counsel for the petitioner. In this petition under section 24 of the Code of Civil Procedure, the petitioner has applied for transferring title suit, which indicate MAT number 112 of 2024, pending before the Court of Learned District Judge Sonitpur at Tezpur to the Court of Learned District and District Judge Jorhat. The learned counsel for the petitioner submits that the respondent herein is the husband of the petitioner, and the respondent has instituted one title suit, being title suit which indicate MAT number 112 of 2024 before the Court of Learned District Judge Sonitpur. And the present petitioner has received notice in the same. The learned counsel for the petitioner further submits that the petitioner is working as ward Sahayika at where she has been working.
Lordship, 5 AF Hospital under Air Force Station, Jorhat, Lordship, para 6, Lordship. Page number 4.
She has been working as ward Sahayika in 5 AF Hospital under the Air Force Station, Jorhat. And her daughter is studying at class 9 at Air Force School, Jorhat. And it would not be possible on her part to appear before the court at Tezpur on each and every date, and therefore it is contended that the aforementioned title suit may be transferred to the Court of District Judge Surat from the Court of Learned District Judge Sonitpur. Having heard the submission of learned counsel for the petitioner, I have carefully gone to the petition and the documents placed on record. Petition and the documents placed on record. Let notice be issued to the respondent, returnable inquiries, step be taken by registered post with AD and also by usual process within a week from today. And considering the submission of learned counsel for the petitioner, further proceeding of title suit number so and so pending before the Court of Learned District Judge Sonitpur at Dashboard stands state till a returnable date list after 4 weeks.
And the plea of license. Coming item 3.
May I please, Your Lordship, this is a transfer petition preferred by the petitioner who is wife of sole respondent of the husband, Your Lordship. Husband preferred a divorce petition, Your Lordship, before the principal judge number Kamrup Metro, Your Lordship. Annexure 1 is the petition, Your Lordship. Page number 16. FC civil case number 723, 2024, Your Lordship, has been filed under section 27B, D of Special Marriage Act.
The petitioner is residing at Hailakandi.
Lordship, he is residing, yes, Lordship. Both of them are actually hailing from Hailakandi. Petitioner at present residing in Hailakandi, Your Lordship. Her original house is in Hailakandi. So,
And
also,
the respondent?
respondent is also hailing from same village, Lordship, but he is staying in Guwahati. He preferred a petition for divorce here in Guwahati, Kamrup Metro, Your Lordship. But marriage was registered at Kachar district, Your Lordship.
Okay.
Annexure 2.
Okay. At what stage the case is pending now?
Lordship, for appearance of petitioner.
Appearance.
And she also.
Third Minister, your good name?
R.H. Chaudhary.
R.S. Chaudhary, learned counsel for the petitioner. This petition under section 24 of the Code of Civil Procedure is preferred by the petitioner for transferring of FC civil case number 723 of 2024 filed by the respondent stroke husband under section 27 within bracket B and within bracket D of the Special Marriage Act 1954 for dissolution of the marriage. The learned counsel for the petitioner submits that the petitioner and the respondents are husband and wife and they belongs to the same place of Isingsa Part 2 under Hailakandi Police Station. And their marriage was also solemnized at the said place, and thereafter the respondent is residing at Guwahati.
Guwahati, Your Lordship. Temporary address. Page number 2 of
And
the petition.
presently the respondent has been residing at Guwahati and he has instituted the divorce proceeding before the learned principal judge family court number 2, Kamrup. And that the petitioner is residing at Hailakandi in her native place. And it would be inconvenient for her to appear and contest the aforementioned proceeding before the family principal judge family court at Kamrup. And therefore, Mr. Chaudhary contended that FC civil case number 723 of 2024 may be transferred from the Court of Principal Judge Family Court number 3, Kamrup M, to the District Judge Hailakandi. Having heard the submission of learned advocates of the parties, I am going for the petition and the documents placed on record, and also there is the documents placed on record. Let notice be issued to the respondent, returnable in 4 weeks that be taken by registered post with AD and also by usual process within a week from today. List the matter after 4 weeks. Considering the submission of Mr. Sodori, learned counsel for the petitioner, and also the facts and circumstances on the record, further proceeding of. How many proceedings are going on between the parties?
Worship, wife has filed an MRDV case registered as 116.
Where it is pending?
Is pending before the Court of Learned Additional Chief Judicial Magistrate, Hailandi, Your Lordship. It is at notice stage.
And 498 proceeding?
No, Lordship. It is here in Guwahati, Your Lordship. She filed an FIR.
So in that case, he has to appear here.
Lordship, she lodged an FIR before the police and civil like that. Your Lordship, till today. Actually, she was legally color-minded.
Having heard them. Further proceeding of FC case number so and so pending before the Court of Learned Principal Judge Family Court number 2 Kamrup M Guwahati stands state till returnable that list after 4 weeks.
Number 21, matters for orders.
Please, Your Lordship. Your Lordship, as per order dated 12/9/2024, we were directed to furnish a copy of the records available. Your Lordship, I want to furnish before Your Lordship the copy of the record.
Have you furnished a copy to
Yes, Your
Learned
Lordship.
Yes, my
counsel?
lord, today itself, my lord.
Today itself.
Yes, my lord, but I have not, after going through this record, my lord, but there is an order dated, order about enquiry report, my lord, but it is not enquiry report. I have seen that WS and written statement, or my lord, nothing enquiry report is inserted here. Enquiry
Your
report is-
Lordship, we could not gather the enquiry report. Whatever documents you could gather, we have
There
provided.
is no enquiry report actually. This is a written statement or WS and.
Where it is mentioned about enquiry report?
Regarding pursuant to the order dated 16/8, second parameter, 16/8/2024 register of this court has submitted an enquiry report in respect of the receipt of the LCA WCPC 14.
No, that enquiry report is available in the record.
Oh, okay. Oh, it is
Now,
in the
now, yes,
Oh,
yes. That enquiry report has already been submitted.
Submitted.
Now, my question is,
No, have not been received. Perusal the report indicates that record of WC case number 14/2009 has not been received by the registry of this court.
yes, that has not been received.
Yes, my lord.
Therefore, the learned counsel submits that he may furnish the copy of the
with it
records
available.
available with him. He
Yes,
has
madam.
furnished it today. Now, my question is, can we hear the matter on the basis of these documents and dispose of the appeal?
Without being,
Pardon?
without having.
No, whether
the
these
enquiry
documents
report.
are sufficient.
Well, I have to go through it and I have take instruction from my client. my lord.
Okay,
Fix this matter for hearing, my lord. By the time I will contact with my client.
okay. Person to, no, heard Mr. Dutta, learned counsel for the appellant, and Ms. K. Debe, learned counsel for the respondent. None appears for the respondent number 2.
No, two is.
Oh, you are 2. Acha.
Namtu
Your good name?
A. Bora.
Ms. A. Bora, learned counsel for the respondent number 2. Person to order dated 12/9/2024, Mr. Dotto, learned counsel for the appellant has furnished the copy of the records available with him. Miss Devi, learned counsel for the respondent, submits that she has also received a copy of the same. And she submits that she may be granted some time so as to enable her to go through the documents furnished to her today.
Yes, ma'am, today. sir.
And in the meantime, she submits that the case may be listed for hearing. Where is accordingly allowed, recessal list the matter for hearing on.
That's all right.
22.
Okay, so that's it. As per the office note, notice has been duly served and LCR has also been followed.
I am appearing on behalf of respondent number 1 to 6.
How many respondents are there?
Respondent 1 to 6 and performer respondent 1 to 6.
What's it? Both the parties are represented by their engaged counsel.
Also, matter is ready for hearing.
It is submitted that the matter is ready for hearing and the LCR has also been received. Accordingly, it is provided that recessal is the matter for hearing in usual course.
Also, date may be fixed for it.
Why?
Also, otherwise.
Lot of matters are there.
Also, yeah, first week of December it will be possible. Any date, first week of December.
First week of
First week of December. A date may be fixed also.
3rd December.
3rd December. No, sir.
Item 23.
Lordship, service completed lordship and LC also received lordship.
So hearing.
Lordship.
Heard Mr. P. Bordolo, learned counsel for the appellant. Then also heard Madam,
Lordship, I'm appearing for respondent number 1 and 2.
your good name, please.
K. Bhattacharya on behalf of.
K.
senior counsel
Bhattacharya,
P.
learned counsel for the respondent number 1 to
1 and 2.
1 and 2.
Yes, Your Lord.
How many respondents are there?
4. 4 respondent lordship.
Then whether service completed upon
Lordship,
the
as per office note, respondent. As per office note, lordship, as per office note, respondent appeared. We filed their Okalandama.
Yeah, to clear no, respondent.
Has been listed as respondents.
1 and 2 নাম আছে কখন মাস চেক করে তবে কিন্তু আগে তো নোটিস আছে বলতে তবে অফিসিয়াল
One and 2. Ukala namat karkar namas. Okay, we'll fix the matter for hearing. In the meantime, you check it whether service upon the respondent number 3 and 4 completed or not.
But in office note, it has been reflected as respondents, not clearly mentioned 1, 2, 3, 4 like that.
Only one Okalandama is available and the name of madam is reflected here.
Yes, Your Lordship, for 1 and 2, Lordship.
Learned counsel for the respondent number 1 and 2. Though in the office note dated 23rd 10 2024, it is reflected that Okalandama has been filed on behalf of the respondents, yet it has not been clearly indicated on behalf of which of the respondents the Wakalatnama has been filed. But on perusal of the record, Kobe, for Jesus week, yeah. Jesus week.
Appeal not.
People, perusal of the record indicates that Wakalatnama is filed only on behalf of respondent number 1 and 2. In view of above, it is provided that the learned counsel for the appellant shall take fresh step upon respondent number 2 and 3.
3 and 4.
3 and 4, sorry. 3 and 4 by registered post and also by usual process. Registered post with AD and also by usual process within a week from today. Place the matter after 4 weeks.
I don't. Possibly that may be. Only that for orders.
4 orders, I don't think there is a requirement of fixing a date.
4 weeks. Lord.
Item 24.
Especially in this case, service completed and LCR also received money.
Pardon me, sir?
You
You can learned counsel for the appellant and Mr.
SS Bora.
SS.
HS Bora.
SS Bora, learned counsel for the respondent. It is submitted at the bar that service completed and the LCR has also been received and the matter is ready for hearing. Accordingly, it is provided that registrar lists the matter for hearing in usual course.
25.
In this case also, same my lord.
Okay, same order.
Problem.
26.
That will be lord. My lord, as per official dated 23/10, my lord. Service report is awaited. My lord, may I submit one thing, my lord? Unless, my lord, proceeding is not proceeding is stayed, my lord, the respondent will never come. My lord, the lady, the wife of the respondent, she filed 2 cases before the PGM Kamrup, my lord. And the respondent, the husband of the petitioner.
No, you first tell me whether notice upon the respondent serve or not.
It is not sub 2 times I have taken step. 2 times registered as well. He was an advocate, practicing advocate in Guwahati High Court. Now he voluntarily leave Guwahati, the respondent.
You cause service of notice by Dusty mode then?
Dusty mode, it is not possible.
Why?
Your lordship, kindly see page 18. Page 18. His brutality. Kindly see.
No, that we will look after that only after causing service of notice upon him.
Dusty, it is. Kindly see your lordship page 18. The petitioner was tortured brutally. Kindly see.
No, but you first cause service of notice upon him.
Dusty is not possible.
By whatever means it is available, you can take it.
And the lady, she has to go Bilasipara from Guwahati. 200, more than 200.
No, proceeding is already stayed.
Pardon?
Proceeding is stayed.
No. That is why I am praying to stay the proceeding which is pending before the Bilasipara. And she has to go from Guwahati to Bilasipara, which is more than 250 kilometer distance. And up and down more than 500 kilometers.
Okay, heard Mr. S.A. Ahmed, learned counsel for the petitioner. Office note. dated 23rd/10/2024 indicates that service report upon the respondent is still awaited. List the matter after 2 weeks, awaiting service report upon the sole respondent. And considering the submission of Mr. S.A. Ahmed, Learned Counsel for the petitioner, further proceeding pending before the Court of Learned. Where it is pending?
LDGM
Before the Court of Learned SDGM Bilasipara stands state till returnable date.
Civil Judge Junior Division, my lord. Civil Judge Junior Division.
Civil Judge Junior Division Bilasipara stands state till returnable date. List after 2 weeks.
Obligement.
After 2 weeks.
On 13th November. Item 27.
The matter today fixed for consideration of prayer of stay upon the proceeding of the trial court, which is pending between the parties in the Court of Learned District Judge Dharam. We are before your lordship by challenging one order which was passed on 8/10/24 for rejection of a prayer of the present petitioner thereof with regard to recast of issue of bigamy. Because at the prima facie when the case was filed, there was 2 issues against in this case, against the respondent. First was bigamy and second was insanity. So by passing the said order, the Honorable Trial Court has rejected the first issue accordingly by holding that she is one and same person as on the basis of some without any appropriate materials. So that is the part under challenge before your lordship in this proceeding. Because Order 14 Rule 5 prescribes as per CPC, any issue can be recasted before pronouncement of judgment. Even the appellate court is also empowered to do so. And in support of my submission, I would like to produce one judgment before of the Honorable.
My lord, here I filed my wakalatnama only on Monday, my lord, for sole respondent. Some time.
Want to file objection?
Objection.
So,
Okay, let her file objection.
yeah, we have no objection to receive her objection, but at the first of all, there are 2 dates are awaiting to end of the proceeding. So till then, till finalization of this matter, so subjected to payment of monthly penalty, like further proceeding may kindly be stayed. Because the proceeding is initiated by myself, not by them. So there is no prejudice to the respondent if the further proceeding be stayed till final disposal of, because without decision of this recast of an issue properly in the eyes of law, in accordance with law, there shall be great prejudice to the present petitioner also. So let us first adjudicate this issue before this honorable court, then trial may continue again.
My lord, your lordship may pass the interim order, my lord, after filing of my objection, my lord. So I may be heard then, only then, my lord. A short date may be given.
Heard Mr. Epal, Learned Counsel for the petitioner, and Madam Sodori, Learned Counsel for the respondent. Ms. Sodori submits that she has filed wakalatnama on Monday, and she may be granted some time to file objection. Here is accordingly allowed. Please the matter.
On 13 November.
It will be too late, my lord.
Sorted.
Let it be
8 November. 8 November. 29.
Yeah, please, my lord. The office report says the service is not complete, my lord. So let us wait for service report, my lord, because steps were taken on 21st September. So let us wait for service report, my lord, and the connected appeal has already been admitted.
Heard Mr. Edas, Learned Counsel for the applicant.
Applicants.
I am passing the order in IA.
Yes,
In IA, you are applicant.
Yes, applicants.
applicants. Okay. Office note dated 23rd 10 2024 indicates that neither ID card nor unserved notice has been received by the section in respect of respondent number 128. List the matter after 2 weeks, then
After service of my lord.
service, it may not be cause served, so no service could not be effected for 1 year. Then-
I'll let after 3 weeks of probation, because on 21st steps was
Okay,
taken, it has
after
gone
3 weeks.
after 3 weeks.
Awaiting service report upon respondent number 128.
And interim order to continue.
Interim order passed earlier shall continue.
I am deeply obliged.
30, 31 and 32.
May I please, Your Lordship, this is a condemnation delay petition for filing restoration, which is dismissed for default 23/1/2018. Delay is 1462.
Pardon me, see your good name?
P. Sarkar.
P. Sarkar, learned counsel for the applicant. This application under Order 41, Rule 19, read with Section 151 CPC, is preferred for restoration of connected RSA number 100 of 2003, which was dismissed for default by order dated 23rd 1/2018 for non-prosecution. Let notice be issued to the respondents returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. List after 4 weeks.
31 is missed case for restoration, but 32 is condemnation of delay for filing, condemnation of delay filing restoration petition, which is dismissed for default.
31 is same.
Yes, you're not 31 is missed case, restoration petition, but 32 is condemnation delay. IA 3173.
No, I am asking you about 31
Yes, your lordship, 31 is.
for restoration.
Yeah, restoration petition, your
31
lordship,
is same.
RSA number 110.
Pardon, Sarkar, learned counsel for the applicant. This application under Section 5 of the Limitation Act 1963 is read with Section 151 of the Code of Civil Procedure is preferred for condemnation of 1,465 days for filing the restoration petition in the RSA. Restoration of the RSA number 110 of 2003, which was dismissed for default on 23rd 1/2018 for non-prosecution. Let notice be issued to the respondents returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. Place the matter after 4 weeks.
Thirty-five.
This petition unfortunately come on the most, the order, this is the first day came. When only latest come on the orders column, it should be come in motion. I have not mentioned because of it, that it is in supplementary list. Yeah, therefore, as fortunately it come the list, that is I am not mentioning, but case is that the petitioner, that is a tenant, was tenant of respondent from 1994. And he was continuing the possessing the, and in continuing tenancy.
in 2003, the respondent refused to take the rent, and we have come to the court and deposited the rent at the court, and continuously we deposited the rent at the court, and they also take out the money from the court. On 2014, they have filed in suit for ejectment on the ground of defaulter and bona fide requirement. Though we have continuously paid the rent at the court. And what is happened? We have filed WS denying their claim. PW the evidence was taken, cross examination taken place, PW together.
Now tell me at what stage the proceeding is pending?
Now it is evidence stage.
Evidence stage. How many witnesses have been examined?
No. What is our case is that when our evidence came done, we have taken adjournment because of fact the main whole case is based on the rent control case. Whole case is based on the they are specific abatement in the page 70 and evidence in 78, 80 page 80 logical fine. They have themselves said we said we applied for the certified copy of those cases, Salan and all. But the court could not give that rent control court that is not giving those certificates. Therefore, we have no other option but have to file an application order 30 Rule 10. And that is why we filed we take it to a court, also will find one page 139. We have first will have a look on page 111 and Annex 12. Annex 12. This application we have filed. The defendant intends to file a petition under 30 Rule according record from the District of Kasar for purpose of evidence to defend, but due to non-collection of disposal from the record, could not arrange this file. Such another date is required to grant the filing of the parent. And the payer is also fine. They would please to give the another date of filing of the petition to end of justice. And what happened? The court also filing 112. Annex 13. Today, the both side is present. Defendant filed a petition of under Rule Order 30 Rule 10. We are not filing a application under Order 30 Rule 10. We take adjournment order and whatever they did, what the final order they rejected, actually evidence is closed. If my defense had been established without the possible note, without that record, I could not establish my case. Our specific case was that we have continuously paid, and Lordship have just looked this page 78. But then Lordship clear the matter. Page 78. Their course examination Lordship fine. Page 78, Lordship. The last part of the evidence. It is a fact that Deepak Paul deposited rent in the court in the name of and we have received the notice from the court. Was it fine? And we have been receiving notices from the court regarding deposit of rent. But tenant, some cases, I cannot say exactly how many cases I received the notice. And Lordship then kindly turn to page 79. We have not filed any objection in this case, that is rent control case. Lordship will find. And page 80 lordship fine. I visited from court, but we have not filed any objection. In this case. They cross-examined, they said, even then they say I am defaulter. Defaulter from 2003. And that is why to establish my case without the record, I could not. And this, as this order was, is erroneous and contrary to the records, we have filed immediately filed a review petition at the court stating therein, but that review petition was dismissed, and for that we compelled to come this court for the end of justice. My simple prayer is that in Salem ad hoc bar assistant case, the 3-time adjournment is not a mandatory one, it is a directory one. If the reason is for the end of justice, that can be given. And in this case, the adjournment which were allowed, I have given annexed all orders on that ground, that for the record.
So this annexer 13 is the impugn order.
Yes.
So your pair was to call for the RC record.
Record and allow to place my evidence. The evidence is closed. They close the evidence. How can I defense evidence can give without that is the only point of the folder, and which is on with the basis of the court record.
Heard Mr. P.P. Borua, learned counsel for the petitioner. This petition under Article 227 of the Constitution of India, read with Section 115 of the Code of Civil Procedure, the petitioner has challenged the correctness or otherwise of the order dated 23rd/4/2024 passed by the learned Civil Judge, Junior Division Number 4, Kasar Silsor, in title suit number 15 of 2014. It is to be noted here that by impugn order dated so-and-so, the learned trial court has dismissed the petition filed by the petitioner. Dismissed the petition number 114 of 2015, filed by the petitioner under Order 13, Rule 10 CPC for calling of RC cases from the District Record Room, Kasar, and also prayed for fixing another date for filing a petition for the same. Mr. Borua, learned counsel for the petitioner, submits that the petitioner has already deposited the amounts before the court, and unless the record of RC cases were called for, the petitioner would not be able to establish his case. But the learned trial court has illegally and arbitrarily dismissed the petition and thereby caused prejudice to the petitioner. And therefore, Mr. Borua contended to set aside the impugn order dated 23rd/4/2024 and to allow the petitioner to adduce evidence, and also direct the learned trial court to call for the RC cases from the District Record Room. Having heard the submission of Mr. Borua, learned counsel for the petitioner, I have carefully gone through the petition and the documents placed on record and also the order dated 23rd/4/2024. It appears that the learned trial court has dismissed the petition on the ground that the petitioner has not mentioned in the petition details of the RC cases. And the petitioner has already availed several adjournments, and therefore rejecting the petition close the evidence of the defendant. Stroke petitioner. But having heard the no, having considered the submission of Mr. Borua. No, it is to be noted here that right to fair trial is a fundamental right. And in fair trial, fair opportunities have to be afforded to both the parties to establish their cases. In the present case, though some opportunities were already afforded to the petitioner, yet having regard to the nature of disputes and the dispute between the parties and submission of learned counsel for the petitioner, this court is of the view that one more opportunity has to be given to the petitioner to adduce evidence and also issue direction to the learned trial court to call for the record of to call for RC cases from the district record room. Accordingly, it is provided that the learned trial court shall afford another opportunity to the petitioner to adduce evidence and also to call for the record of RC cases from the district record room, and thereafter to proceed. No, thereafter to hear and dispose of the matter in accordance with law. In terms of above this, CRP stands dispose of at the motion stage itself.
Only one thing, madam. I think your lordship has mentioned the petition number as 114 of 2015. Hello, it is actually 114/2015 dated 23rd of April 2024, madam. Lordship may kindly.
The
petition is at page.
No, in the impugn order, number of the petition has been mentioned.
114/15. It's not of 2015, madam.
Item,
It's of the same date.
Okay.
Give you.
item 33 for hearing.
If my learned friend has informed that
Appellant
appellant expired.
Unappellant.
So I have to file appropriate application for substituting.
Appeal expired on
Yes.
6/4/2023.
As agreed by learned advocates of both sides, registration is the matter after 4 weeks.
But
In the meantime, in the meantime, step for implementing the legal heirs of appellant number,
Appellant.
appellant,
Sole appellant.
sole appellant.
Expired
Sole
on
appellant shall be taken as it is informed that the appellant already suffered demise on
6/4/2023.
6/4/2023.
Have waited.
Okay, less the matter after 4 weeks.
highly obliged.